Australian children are being placed in harm's way thanks to the family court laws in Australia. One case here in New South Wales, a young boy named James told his mother about being abused by his father. It was reported to the New South Wales Department of Family and Community Services and the police, but the family court said the claims were malicious and gave full custody to James's father. He was 6 years old when the family court judge ordered him to live with his father. He was only allowed to see his mother every second weekend. James described living with his father as hell on earth. His father was sexually, physically, verbally and emotionally abusive. This went on for 7 years. When James was 12, he was regularly running to the police for help. Eventually, police took out an AVO against James's father on his behalf. James begged and pleaded for authorities to let him live with his mother, but the family court orders forbade it. Yet the law states that a child at the age of 11 can say who they want to live with. They took James's rights away from him. Child protection services are state-based, the family court is federal, and because of this, children's needs and safeties are being forgotten about. The ABC sent an affidavit filed by Family Community Services in James' care that states it received 24 risk of harm reports from a number of people in relation to James during the years he lived with his dad. These reports were often ignored, they were only ever raised. These reports, nothing ever came of it. One note stated Family Community Services intervened in an earlier family court matter between the father and a different partner after having substantiated he sexually abused a child from that relationship. In total, 3 former partners had alleged sexual assault against James's father, but only one case was substantiated by state authorities. The Australia Law Reform Commission recently conducted a wide-range review of federal family court system and found it posed an unacceptable risk to children and should move these laws to state and territories, the same as Child Protection Services. Under the Family Law Act of 1975, the court most considers the child's safety and rights, but they don't. The gap exists because the Queen Mother put laws in Australia that protect sex offenders. These laws are still in place. One law states that a convicted sex offender can apply for supervised contact and full custody of a child that they have sexually abused. It is up to an independent children's lawyer who will convince the judge that it is appropriate for that child or children to spend time with the abuser, and in most cases that child is put in that situation. These judges will say they are doing their job, in which they are not. If a parent can afford a solicitor, they can get away with murder. These family laws courts need to change. No sex offender should be allowed in any family courtroom. The only place for a sex offender is in a fire pit where they should be burnt alive. Thank you for listening. Here at Exposing the Truth, that's what I intend to do. So wherever you are in the world, good morning, good afternoon, good evening, and good night.